I just want to say Happy Hanukkah, Merry Christmas, and if anyone wants to accuse me of being politically incorrect, Happy Holidays. Welcome to the Goldwater Institute. As you know by our namesake, the Goldwater Institute is about advocating individual freedom, individual responsibility, economic liberty, and limited government. And I assure you today's event is not going to deviate from those principles. But before introducing Bob Levy, today's luncheon speaker, I wanted to thank you first for this amazing outpouring of support for our cause, for all of our cause, the cause of freedom. We simply cannot advance liberty without your help. And I want to thank you for your time, because being here to receive these ideas is crucial to spreading them, and your generosity, which makes it possible. I'm especially thrilled to introduce Bob Levy. The reason why is there's not much left of the original meaning of our Constitution, but what we've got, much of that is his doing. And every time I introduce Bob, and this is a true story, every time I've introduced him, it's only my second time, but so far, every time I've introduced him, some major event has happened in constitutional law that has restored the original meaning of the Constitution. The last time I introduced Bob Levy, it was right after the Heller decision came down, a case in which he co-counseled. And in an era of an evolving Constitution, he achieved the seminal feat of having the court declare that the Second Amendment means what it says. No small feat. Now this year, Bob happens to be talking to you today at this luncheon shortly after the Virginia federal court struck down the individual mandate of the Obama healthcare regime. Now, Bob has talked extensively about how the individual mandate is unconstitutional in multiple levels, in multiple media sources, and behind the scenes he's been bubbling with ideas and strategies and tactics. So I regard today as just another time that I'm introducing him after some significant new success in constitutional law that we can attribute to his tireless advocacy and scholarship. And speaking of tireless advocacy and scholarship, the fact is Bob Levy has written extensively in all the areas of constitutional law that originalists hold dear. Every media source has published, every major media source has published his work. And most recently, his most recent book, The Dirty Dozen, I think, even though it came out in 2008, is contributing to a culture change where courts are becoming increasingly willing to consider re-examining the idea that something went grievously wrong in the 1930s and 40s when the Supreme Court, after the court packing thread, suddenly decided that the federal government was not of limited and enumerated powers. So Bob is not just a lawyer, he's a culture shifter. And today, he's going to help us understand how we can fight the looming culture shift and the looming constitutional law shift that is threatened by the Obama administration. And he's very well qualified to do that. Bob Levy is chairman of the board of directors of the Cato Institute. He joined Cato as a senior fellow in 1997 after 25 years in business. And I just want to underscore this. Bob Levy is not a pointy-headed academic. He comes from a real-world experience of what it's like to try to make a living, to get ahead, to be successful. And that grounds everything he does. Everything he does has got a deeply pragmatic basis to it. He earned his PhD in business in 1966, and then he founded the CDA Investment Technologies, a major provider of investment information and software. After leaving the CDA in 1991, Bob went to George Mason, where he was the chief articles editor of the Law Review. After receiving his JD, he spent 2 years clerking for Judge Royce Lamberth on the U.S. District Court and Judge Douglas Ginsburg on the U.S. Court of Appeals, both in Washington, D.C. For many years, Bob Levy was an adjunct professor of law at Georgetown University. And before I continue with listing everything he's accomplished, I can assure you we have a complete bio in the packet. It is simply one of the most impressive backgrounds that you could ever have in bringing a constitutional scholar to talk about constitutional law. In fact, I say there are few, if any, people who are more qualified to talk about today's constitutional issues than Bob Levy. And for that reason, I think I'll sit down and enjoy the show.
Well, that was some great introduction. Thank you very much. And I do have two claims to fame, one of which is I think I'm the only federal law clerk ever who's been older than both of the judges that we clerked for, because I didn't get out of law school when I was 54. And then clerked for judges, both of whom were a year, 2 or 3 years younger than I was. So for 2 years, the folks in the district court house in the U.S. Court of Appeals in Washington, D.C., the marshals guard the building with great diligence, and they would say to me every morning for 2 years, good morning, Your Honor, because they couldn't believe anybody as old as I was as a law clerk, and I never disabused them of that notion. Of course, when I got up in the chambers, they told me to go change the water in the jury box. But I was treated with great deference in the halls of the courthouse. The second distinction I have is that I may be the only attorney you're going to meet that every case I have ever litigated has been a victory in the U.S. Supreme Court. What I don't tell folks is that I have only litigated one case. So I have zero practical experience. I mean, here you have Nick and Clint, who are two of the best legal minds in the country that have litigated over and over and over again. And I've litigated one case. So you're going to hear from an inexperienced lawyer. It is great to be here. When I look out over this crowd, I see so many young faces. It's quite a contrast. I live in Naples, Florida, where the average age is deceased. So it's good to see some younger faces. I'm part of this group. They're older than I am. They invited me to join. Their deal is they meet as often as they can. And at least once every 10 years, if they haven't seen each other, they get together for a reunion and they go out to dinner together. So this all started many, many years ago. They're 40 years old and they get together and they vote and they decide to go to dinner at the Ritz-Carlton because the waitresses there were really very attractive and they wore these very provocative outfits. So 10 years go by and they're 50 years old and they get together once again and they vote another time to go to dinner at the Ritz-Carlton because the food and the wine there is absolutely spectacular. Fast forward another decade, they're 60 years old, they get together, they vote to go to dinner at the Ritz-Carlton because it's smoke-free and quiet, and you can hear yourself talk. Then another 10 years, they're 70 years old, they get together, they vote, and they decide to go to dinner at the Ritz-Carlton because it has elevators and wheelchair access. And finally, just a few weeks ago, they turned 80 years old and they all get together and they vote and they decide to go to dinner at the Ritz-Carlton because they'd never been there before. So there, so many of us know how close to true that all is. I'm going to talk today about constitutional relevance in the age of Obama, highlighting the constitutional implications of two topics in today's news, the right to keep and bear arms and health care, although I'm happy to answer questions about other subjects as well. Before I get to that, though, a couple of constitutional basics, and then a brief discussion on how to interpret the Constitution and the Supreme Court confirmation process. I want to begin by going back to 1776, 13 years before the Constitution was ratified. There was, of course, the Declaration of Independence. So what, if any, link exists between those two documents? Well, this is what Jefferson wrote in the Declaration. The cardinal truths are these, that all men are created equal, that they're endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. And then Jefferson added, to secure these rights. And the important word there is secure. Notice he didn't say grant. He said secure. So these are rights that we already had. We did not get them from government. We, as a matter of fact, confer power upon government. Government gets its power from us. We do not get our rights from government. So to secure these rights, that's the function of government. Governments are instituted among men, deriving their just powers from the consent of the government. So our rights to life, liberty, and the pursuit of happiness imply the right to live our lives as we wish, to pursue happiness as we think best, provided only that we acknowledge the similar rights of others to do likewise. And that is a very libertarian principle, and I think it's fair to say that the founders were libertarian. Now, the Bill of Rights was added 2 years later, in 1791. Why wasn't the Bill of Rights included in the original document? Well, Madison and Hamilton in particular, Federal State before, thought that a Bill of Rights was not necessary, and that's why it wasn't included. And they argued, both of them, that, look, there are rights, like the right to a free press, for example. It didn't have to be guaranteed. Why? Because the very nature of the federal government that we established was a government of limited and enumerated powers. So if there was no power acknowledged in the Constitution for the federal government to interfere with the free press, then there was no need to set forth in the Bill of Rights the right to have a free press. If there's no power, we don't need a right that protects against the exercise of the power. Now, Madison had another problem, and that is he thought that the listing of certain rights might be misinterpreted to mean that we didn't have any rights that weren't listed. Now, he avoided that. Of course, it wouldn't be possible to list each and every right that we had, so he avoided that problem by adding the Ninth Amendment, which, if you recall, protects unenumerated rights, that is, even rights that are not expressly listed in the Constitution. The Ninth Amendment says we have those rights even though they're not listed. We retain those rights. We had them even before the Constitution was written, even before government was formed. Now, ultimately, Madison did switch sides, and he joined the Anti-Federalists in support of the Bill of Rights. Why? As an extra added precaution. Because without the promise of a Bill of Rights, the Constitution might not have been ratified. And so the pro-constitutionalists promised a Bill of Rights. But strictly speaking, most of the rights secured by the first 8 amendments in the Bill of Rights were already secured by the original Constitution. Now, Madison also discussed what has become known as the Madisonian dilemma, and that is pitting, on the one hand, majority rule, and on the other hand, these inalienable rights that we have. Can those two principles be reconciled? In The Tempting of America, former Judge Robert Bork set out to reconcile those two principles, and this is what Bork wrote. He said, quote, "In wide areas of life, majorities are entitled to rule if they wish, simply because they are majorities. There are nonetheless some things majorities must not do to minorities. Some areas of life in which the individual must be free of majority rule." And of course, he's talking about those areas that are protected by the U.S. Constitution. Now, I think Judge Bork is clearly onto something, but I believe he gets the Madisonian vision exactly backwards. It was rather that the founders instituted a plan whereby in wide areas, individuals would be entitled to rule because they were born free. And in a very few areas, majorities would be entitled to rule, not because they are inherently so entitled, but because they are authorized by the U.S. Constitution, which gives majorities a very narrow reign to exercise power. Of course, that leaves us with a critical question, and that is, what is it that our Constitution authorizes? And for that answer, we turn to competing theories of constitutional interpretation, offered most prominently by 2 members of the current Supreme Court, Justice Scalia, also Justice Thomas, I would say, advocating principles of textualism, and Justice Stephen Breyer, advocating a quite contrary principle called the living Constitution. So these are the 2 most widely applied theories of constitutional interpretation: textualism and the living Constitution. You may have heard of other variations, so I want to define just a few terms. There are many conservative legal scholars who suggest that the proper guidepost for constitutional interpretation is the original intent of the framers, and I'm sure you have heard that. Strictly speaking, original intent is not textualism. Scalia and Thomas are textualists. They rely less on the original intent of the framers and more on the original meaning of the word, the text of the document. A judge, they argue, should attach primary importance to the words that are actually in the Constitution, and here's what Scalia wrote, and I think it summarizes this concept very nicely. He said, and I quote, "It is the law that governs, and not the intent of the lawgiver." Now, it's true that most textualists are also originalists And what that means is, and this is where the terms are a little bit confusing. We have original intent on the one hand, we have originalists on the other hand. Textualists are originalists. But what that means is that textualists interpret the Constitution in accordance with those words' meaning when the words were originally ratified, not necessarily the meaning that would be derived from a modern reading of the text. Original meaning is not, however, synonymous with original intent. Original intent does not focus primarily on the words, but on the values and the objectives of the drafters and the ratifiers when they enacted a particular provision. The difficulty, of course, in applying original intent is that it begs several questions. Which drafters or ratifiers are authoritative? As you may know, Hamilton and Madison, for example, had widely varying views about, like the General Welfare Clause. How do we know what their intent was? Madison gave us some records of the Constitutional Convention, but there was very little else in the way of recorded material that would tell us what the original intent of the framers were, and how do we reconcile these contrasting views of two of the, or more of the framers. Now, not only doesn't textualism equate to original intent, it also differs from another term that you've heard identified with conservatives, and that is strict construction. Scalia, again, explained the difference. Even though you have read over and over again, I'm sure, that conservatives are strict constructionists. This is what Scalia said. I am not a strict constructionist, and no one ought to be. A text should not be construed strictly, and it should not be construed leniently. It should be construed reasonably to contain all that it fairly means. So if you wanted to interpret a Constitution ratified in 1789, what is the very best tool that you would have at your disposal? It would be a contemporaneous dictionary. A dictionary that would define the meaning of the words as they were used when they were ratified in 1789. And that dictionary would not define the words strictly, and it would not define the words loosely. It would define the words reasonably and plainly in accordance with their actual meaning at the time. Now, there is this opposite theory, polar opposite theory, and it's a theory preferred by most of today's liberals, the so-called living constitution theory. Liberals want the Constitution to be interpreted in light of new circumstances, a malleable document that can be molded to meet concurrent societal demands. And Justice Breyer described this living Constitution as one, and here's a quote, designed to provide a framework for government across the centuries, a framework flexible enough to meet modern needs. Our constitutional system, says Breyer, requires structural flexibility sufficient to adopt substantive laws and institutions to rapidly changing social, economic, and technological circumstances. Now, the textualist response to that is the framers provided an amendment process for structural flexibility. So if you think the Constitution needs to be updated, it should be updated by amendment, not by pretending that the written document doesn't exist or that the document doesn't mean what it quite clearly says. What indeed is the purpose of having a written document if we act as though it's just a piece of paper? Now, bear in mind, when we say that you should focus on the words as written and as they were interpreted in 1789, that does not lock the Constitution into a 1789 framework. There are no textualists that I know, and certainly Scalia and Thomas would not be among this group, that would suggest, for example, that the First Amendment protections for free speech don't extend to the Internet. It is always permissible to examine the words in the document and look at the trajectory of those words and apply those words to modern circumstances and conditions. What is not permissible is to interpret the words to mean something different than they meant at the time. Where does our president stand? I think the answer to that, I should say, as a prefatory matter, that near term, if nothing, unless something unpredictable happens to Kennedy, who's the swing vote on the court, or one of the four conservative justices, President Obama is probably not going to have much impact on the ideological mix of the Supreme Court. We have liberal Justice Sonia Sotomayor, who replaced liberal Justice David Souter. We have liberal Justice Elena Kagan, who has replaced liberal Justice John Stevens. And ditto if Ruth Bader Ginsburg retires. Reportedly, she's not in good health, but she too is a liberal who will be replaced if Obama makes the appointment. Will be replaced by a liberal. Now, The fact that he doesn't have any, not likely to have influence on the ideological mix of the Supreme Court doesn't mean that his nominations are not likely to have much influence. He will have an enormous impact on the trial and appellate courts. George W. Bush and Bill Clinton, who of course served 2 terms, they each made about 300 appointments, each over 8 years, to the trial and the appellate court. And today there are a large number of vacancies on the appellate courts. And to put that in perspective, the Supreme Court decides about 75 cases a year. The appellate courts decide about 3,000 cases a year. 2,925 of those cases never make it to the Supreme Court, and so the appellate courts are the final word. The appellate appointments are critically important. What type of judges are we going to get on the appellate courts from the current administration? Well, his choices so far give us some pretty good clues. He believes that our courts, and this is his quote, should stand up for social and economic justice. He wants judges who have the empathy to recognize what it's like to be a young teenage mom or to be gay, poor, or black. Now, there are a lot of liberal scholars who agree with that, although they use other labels, like the label the Living Constitution, as sort of synonyms for empathy and a social consciousness, a conservative response, a libertarian response. Empathy is quite a desirable characteristic. Nobody is suggesting that judges should not be empathetic. The question is whether or not empathy trumps the words that are written in the Constitution as a means of interpreting our law. So if you like the notion of the Constitution and you be bent by empathetic judges who have a social consciousness, then Obama's judicial nominees are going to be your cup of tea. If you prefer originalists who are anchored by the written text of the founding documents, then you better gird your loins during an Obama administration. As a matter of fact, one, I think, reason for, perhaps a major reason, for the broken confirmation process, if you've ever watched a judicial confirmation process, you know it's dysfunctional. One of the reasons, I think, is the court's gradual shift away from reliance on the text to reliance on this living Constitution. Because when the text of the written Constitution is trumped by evolving societal needs, then this judicial function for which we are trying to confirm somebody becomes just politics by another name. So no wonder Congress and activist groups on both sides of the aisle are concerned about the nominee's views on key public policy issues. Why? Because those views might ultimately become law, even if there are explicit constitutional terms that suggest to the contrary. That's what happens when a malleable constitution allows judges to act as if they were legislators. So that's sort of a theoretical backdrop. And now let me see if we can apply that to the real world context of 2 hot-button issues, the right to keep and bear arms and health care. Let me comment first on the 2008 blockbuster Supreme Court case on the right to keep and bear arms, which I played a role with her in the District of Columbia versus Heller. This was filed on behalf of 6 law-abiding D.C. residents who wanted to possess functional firearms in their homes where they lived and slept. So Heller was not about machine guns and assault weapons. It was about ordinary garden variety handguns, and the Heller plaintiffs didn't ask for the right to carry those guns outside the home. That's a question that's going to have to be litigated, but it's a much more complicated question for another day. Heller was the very first case in a series of cases, and Heller was about a simple issue, and that is a pistol in the home for self-defense. You may know that off and on over the years, Washington, D.C. Reclaimed its title, not just the nation's capital, but the nation's murder capital. The D.C. government was totally ineffective at disarming violent criminals, but they did a spectacular job of disarming all of the decent, peaceable residents in Washington, D.C. The laws were quite extraordinary. For starters, no handgun could be purchased or registered in Washington, D.C. And the law was passed in 1976, so at the time we filed the case in 2003, we're talking about a law that was a lot of decades old. So suppose you had a handgun in 1976. That handgun would be grandfathered, and you could keep it. But you couldn't carry it from room to room in your own home without a permit. And the district government had not issued a permit in more than 30 years. What about if you had a rifle or shotgun? You could keep that in your home, but it couldn't be loaded. And if you loaded it, you would be breaking the law. It also had to be either bound by a trigger lock or disassembled. So unless you plan with an unloaded weapon of clubbing somebody over the head with it, it would not be a functional firearm. In effect, no one in the District of Columbia, no exceptions, could possess a functional firearm in their own residence. Well, as they say, the rest is history. In D.C. versus Heller, which was the final opinion of the 07-08 term, Scalia, who wrote the opinion, a narrowly divided court, effectively rewrote the court's Second Amendment jurisprudence. And what he held was, first, the Second Amendment protects an individual right to possess firearms in the home for self-defense, even if that exercise of that right is totally unconnected with militia service. And second, that all of the laws that we challenged in Washington, D.C. Were unconstitutional. Now, after the Heller case, that does not mean that you can't regulate guns. Reasonable gun regulations are still going to be okay. But an across-the-board ban on all handguns in all places for all purposes at all times in all places, that's not reasonable. In fact, it's not a regulation at all. It's an out-and-out prohibition. And the Supreme Court now says in the Heller case that it's not permitted in Washington, D.C. Now, correctly interpreted, we have these two clauses of the Second Amendment. The first clause is pretty clear. The second clause, the operative clause, is pretty clear, which says the right of the people to keep and bear arms shall not be infringed. That defines and it secures the right. We do have this troublesome prefatory subordinate clause, a well-regulated militia being necessary to the security of the free state. What does it do? It helps explain why it is that we have the right. So if you're a member of a well-regulated militia, for sure you have a right to keep and bear arms. It is a sufficient but not a necessary condition to the exercise of your right. It is one reason that you have such a right, but not the only reason that you have such a right. Other reasons would include the right to provide food for your family by hunting, and the right, of course, to defend yourself within your own home. So if the Second Amendment truly meant what the militia advocates said, the militia rights or states' rights or collectivist interpretation said, then the language would be much clearer. It would say a well-regulated militia being necessary to the security of the free state, the right of the states to arm the members of the militia shall not be infringed. But of course the Second Amendment doesn't say that. It says the right of the people. And that's an important term. It's a term that appears in 5 of the 10 amendments in the Bill of Rights. The First Amendment talking about speech, the Second Amendment talking about bearing arms, the Fourth Amendment talking about protection against unreasonable searches, the Ninth Amendment protecting unenumerated rights, and the Tenth Amendment which reserves powers to the states. All 5 of those amendments represent the people, and the people in all 5 of those cases are individuals. We're not talking about states' rights. As a matter of fact, this is the section of the Constitution, the Bill of Rights, that deals with, we celebrated last night, the section of the Constitution that deals with individual rights and not with rights of states. So we guarantee the right of the people by guaranteeing the right of each and every person. Now, not only wasn't the Second Amendment intended as a right of the states, it was actually, and both liberals and conservatives acknowledge this, it was actually intended in major part to protect against the possibility that the states and the federal government might turn out to be tyrannical. We would have individually rights that would protect ourselves against the tyrannical government. Well, I mean, imagine that you had a right that was conceded to be, in part, in major part, a deterrence against government tyranny, and that right could be exercised only in a government-controlled militia when, where, and how the government permitted. That would not be a right in any sense of the word. Many legal scholars, and most importantly, legal scholars even on the left, now acknowledge that the Second Amendment does secure an individual right. So here's how Harvard's Alan Dershowitz, a former ACLU board member, he says, I'm quoting, "I hate guns, I want the Second Amendment repealed." He goes on to say, "I condemn foolish liberals who are trying to read the Second Amendment out of the Constitution by claiming it's not an individual right." We have Harvard's Lawrence Tribe on every liberal's short list for the Supreme Court, and Yale's Professor Akil Amar, and they both acknowledge there is an individual right to keep and bear arms, limited by reasonable regulation in the interest of public safety. So, public safety. In that respect, a tribe and Mar, they agree with the gun rights advocates on two fundamental issues. The first of which is the Second Amendment confirms an individual right, not merely a right that can be exercised collectively in the context of militia service. And second, the right isn't absolute. It's subject to reasonable regulation, and to the extent that there's disagreement, it hinges on what constitutes permissible regulation. That is, where do we draw the line? Well, if the gun controllers, the Brady Center and their allies, are correct in predicting that sensible regulations will be the byproduct of the Heller case, I, for one, applaud that development. But sensible is not what we have in New York City, Chicago, San Francisco, many other major cities. Thankfully, Heller took a major step to restore sensibility in Washington, D.C. However, Washington, D.C. was not the whole story. And for the rest of the picture, we have to turn to a different case, and that was a second blockbuster case this year, 2010, McDonald versus the city of Chicago, which determined that the Second Amendment applies not only to federal jurisdictions. Imagine if we had a Second Amendment that only applied to federal jurisdictions like Washington, D.C., Guam, Samoa, Puerto Rico, and the Virgin Islands, but not Illinois. And it determined that the Second Amendment does indeed apply to states and localities throughout the United States. The District of Columbia is not, as you know, a state. It is a federal enclave where Congress exercises plenary power. And that is one reason why we filed the case in Washington, D.C. We wanted to deal with one basic issue. What does the Second Amendment mean? We didn't want to deal with a second thorny issue, and that is, does the Second Amendment apply to the individual states and the cities? You may know that until the 14th Amendment was ratified in 1868, the Constitution applied only, the Bill of Rights applied only to the federal government. Notice in the First Amendment it says Congress should make no law. So theoretically, a state could make a law that said you couldn't practice Catholicism or you couldn't criticize the government. And maybe that was inconsistent under state constitutions, but it would not have violated the federal Constitution because the federal Constitution did not apply to states. We did find out over 70 or 80 years that the states can be every bit as tyrannical as the federal government, as documented in Clint's great book, Grassroots Tyranny. And so we fought a civil war, slavery being the obvious case in point, where the states were tyrannical. And we passed a couple of amendments after the Civil War, one of which, the 14th, says that the states can't deny to people due process of law or equal protection of the laws or the privileges or immunities of citizenship. And that 14th Amendment was used to apply the Bill of Rights. The technical term is incorporate the Bill of Rights, so that they did apply to the states. For the first time, the federal government could step in and stop the states if they were found to be violating these due process, equal protection, or privileges or immunities. This process didn't happen all in one fell swoop. It unfolded gradually. So there would be a case about the right to free speech, another one about religion, a third one about press, protection of unreasonable search and seizures. And oddly enough, until 2010, there was not a case that addressed whether the Second Amendment would be incorporated. And that's what McDonald did. It decided that the Second Amendment would be incorporated. The criteria for incorporation is whether a right is deemed to be fundamental. And that depends, in turn, on whether the right is, and these are terms of art, implicit in the concept of ordered liberty or deeply rooted in the nation's history and traditions. Now, virtually all of the Bill of Rights qualify, including the First, Fourth, Fifth, Sixth, Eighth Amendments. The right to bear arms, the right to defend yourself in your home, indisputably a fundamental right, and it is no exception to the characterization as a fundamental right. The court said so in the Heller case, and the court said so again in the McDonald case, and that means that the Second Amendment, like virtually all the rest of the Bill of Rights now, applies to Illinois and applies to other states, not just federal enclaves like Washington, D.C. And that should spell the end, we would hope, to draconian state and local gun regulations that constructively bar the use of firearms for self-defense. So precise details about the scope of this right are yet to be determined. From the beginning, this battle for gun rights was structured as a three-step process. Step one was determine what the Second Amendment means, and that was accomplished in the Heller case. Step two was determine where the Second Amendment applies. And now we know it applies everywhere in the United States, and that was accomplished in the McDonald case. Step 3, flesh out the scope of Second Amendment rights. We understand that there are going to be some regulations. The Second Amendment right to keep and bear arms does not mean that a 7-year-old can have a weapon of mass destruction in front of the White House. So there are going to be restrictions on some people, in some places, under some circumstances, for some purposes, and even some weapons. And that is step 3, and it is in the process of being fleshed out. It will be litigation that unfolds over many years. So that's the gun debate up to date. And now let me turn to health insurance, and more specifically the individual mandate. I want to cover this with a brief question and answer session, unusual because I'm going to ask the questions and I'm going to provide the answers. Which brings to mind one of my favorite stories. I hope I haven't told it to this audience before, about Edward Teller, who was commissioned by Truman to go around lecturing about the peaceful uses of atomic energy. And he goes around from city to city and he lectures, and he doesn't like to fly, so he's given a chauffeur to drive him from city to city. And he gives about 24 of these lectures, and the chauffeur says, "Look, Dr. Teller, you delivered this lecture a couple of dozen times. Frankly, I'm getting tired of hearing it. I know you must be getting tired of delivering it. So I've heard it so many times, I can deliver the lecture. I mean, just for some variety, why don't I deliver the lecture? You can stand in the back of the room and you can wear my chauffeur's uniform." So that's what they do. And sure enough, the chauffeur delivers the lecture flawlessly, and everything goes well until the question and answer session. And even there, the chauffeur's heard all of the questions, and he handles them without any problem whatsoever, until one fellow raises his hand and says, "Dr. Teller, you report that you conducted the Boscher-Fox experiment and you got pi over e raised to the 3rd power." Now, you know, I did the same thing. I got pi over e raised to the 4th power. I want to know, is this a substantive difference in our work? Or was this just a typographical error in your article? Of course, the chauffeur didn't know what he was talking about. The chauffeur is a little bit nonplussed, but he says to the questioner, he says, "Look, I mean, you have a PhD?" And the questioner says, "Sure." The chauffeur says, "From where?" He says, "From MIT." The chauffeur says, "You have a PhD from MIT, and you have the nerve to ask me a question like that?" To show you what I think of that question, I'm going to call on my chauffeur. So, question number 1, which I will answer. What's the mandate? And why was it supposedly necessary? The mandate is the centerpiece of the Democratic health bill. It's the unprecedented legal requirement that Americans purchase unwanted health insurance under penalty of law. And President Obama conceded to a joint session of Congress that without the mandate, the rest of the legislation would fall apart, and here's the reason why. The health care bill, one principal objective of the health care bill was to make sure that insurance companies covered pre-existing conditions. Now, insurance companies are not stupid. They know that if they have to cover pre-existing conditions, they're going to lose money. Why? Because their customers are not stupid. And customers will simply not insure when they're healthy. Why insure when you're healthy if you know that once you get sick, you can go to the insurance company. The insurance company has to cover you at that time and cannot even charge you a higher premium. So consumers, being rational, would simply wait. And that means that the health care insurers would be deprived of premiums from healthy persons, which they, of course, need to pay for the benefits that go to not so healthy persons. And so the insurance industry says to Mr. Obama, "Look, we can't cover pre-existing conditions. We lose a fortune. And our customers are simply going to wait until they're sick." And Obama's response is, you know, we're not going to let them wait. We're going to require them to buy insurance now. They may not wait. And if they don't buy now, they're going to pay a penalty, and that penalty will be structured to deter them from waiting until they are injured. So is this mandate authorized as a regulation of interstate commerce? That is the claim. Put somewhat differently, does the power to regulate interstate commerce extend to behaviors such as the non-purchase of health insurance that are neither interstate nor commerce? Now, if an interstate commerce clause is supposed to be the power to regulate interstate commerce, and you have an activity that's not interstate and not commerce, it would seem to be self-evident that there's no authority to regulate. But if you think that the answer is no, you haven't been following the Supreme Court over the past 70 years or so. In particular, the infamous, some of you may have heard me describe this case before, the 1942 case of Wickard v. Filburn. That's when the court said that the power to regulate interstate commerce does extend to activities that are not interstate and not commerce. Filburn grows wheat on his farm. He doesn't buy the wheat. He grows it and he doesn't eat the wheat. He doesn't sell the wheat. He eats it or he gives it to his farm animals. And the Roosevelt administration comes in and says, price for crops is depressed. We need to boost the price for crops to help out the farmers. And the way to boost the price is to reduce the supply. So you, Mr. Filburn, have to quit producing so much. And Filburn says, under what authority are you proposing to make me stop producing? And Roosevelt says, the Interstate Commerce Clause, the power to regulate interstate commerce. Filburn says, well, guess what? It's not interstate. It's all on my farm within one state. And there's no commerce involved. I'm growing this stuff. I'm not buying it, and I'm eating it. I'm not selling it. And the Supreme Court says, essentially, Filburn, you just don't get it. Because, listen, if you weren't out there growing this stuff, you would have had to buy it. And if you didn't eat everything that you grew, you'd have some left over to sell. So by not buying and not selling, you quite clearly have had an impact on the supply and demand of crops, some of which would have gotten into the interstate market, and therefore we can regulate you under the Commerce Clause. Of course, that opened up the floodgates through which the regulatory state was ready to pour, giving the government permission to regulate anything and everything. So now, fast forward from Wickard v. Filburn in 1942 to 63 years to 2005, and history repeats itself. And we have a case called Raich v. Gonzalez, and on its face, Raich is about medical marijuana, but the real issues were quite different. Mrs. Raich is a very sick patient in California. She grew marijuana for her own consumption in her own apartment in order to relieve pain. It was legal, and still is legal, to use medical marijuana, to grow medical marijuana in California, under California law, and she had to have a doctor's order, which she did have. The U.S. Justice Department decided that the federal drug laws took precedence over the state laws, and therefore Raich was a criminal. The real issue in the case was not about the medical effectiveness of marijuana, but rather whether or not there were any limits whatsoever on the exercise of federal power. Raich's medical marijuana cultivation and possession and use was all intra-state, in her own apartment, not interstate, and there was no commerce involved, no purchase, no sale, no money changing hands. And still, Justice Stevens, for a 6-3 court, held that the federal act, the Controlled Substances Act, was a legitimate exercise of Commerce Clause authority. Supposedly, citing Wickard v. Filburn, supposedly because sick patients in California, even though they're using homegrown marijuana under a doctor's prescription, where it's legal, might have a substantial effect on the interstate market, the interstate marijuana market, a market which, as you know, is not even supposed to exist. And if it did exist, if she did put her product into the stream of interstate commerce, there were adequate criminal remedies if she would do that. And by the way, dissenting from that opinion was Justice Thomas, interestingly, because he's a staunch anti-drug warrior, and nonetheless, he believes in the Constitution. And Justice Thomas wrote that Raich uses marijuana. It's never been bought or sold, has never crossed state lines, has no demonstrated effect on the national market. If Congress can regulate this under the Commerce Clause, wrote Thomas, then it can regulate virtually anything, quilting bees, clothes drives, and potluck suppers throughout the 50 states. Well, Obamacare goes even one step further than quilting bees and potluck suppers. Under current laws, you may know, it's illegal to buy health insurance across state lines. So again, there is no interstate market to be regulated, and no matter. The Obama administration claims that forcing Americans to purchase an intrastate insurance product that many of them don't want is permissible, because the failure to mandate the purchase of this intrastate insurance product might undercut a comprehensive federal regulatory scheme involving not just health insurance, but health care in the aggregate. Now, in my view, and the view of the folks here at the Goldwater Institute, that does not fly. Congress may be able to regulate wheat under Wicker v. Filbert, but that does not extend to Congress being able to require that I purchase bread at my local grocery store in order to subsidize wheat growers. And even if Congress can regulate interstate health care, Congress cannot require consumers to purchase intrastate health insurance, especially when the clear purpose of this is to subsidize the insurance companies so they can afford to cover pre-existing conditions. What's the Supreme Court going to say? The plain fact is, we don't know. As the lawyers say, it's a matter of what's called first impression. To my knowledge, the issue's never arisen in the courts. When it came up in the context of Hillary Care in 1994, this is what CBO, the Congressional Budget Office, wrote. A mandate requiring all individuals to purchase health insurance would be an unprecedented form of federal action. The government has never required people to buy any good or service as a condition of lawful residence in the United States. So imagine this hypothetical, and it's parallel exactly to what's going on here. The actual situation is people are going to be forced to buy insurance so that the premiums can be used to subsidize the big insurance companies who can then afford to take losses on another product, which is the coverage of pre-existing conditions. So suppose Obama goes to the food industry and he says, you know, obesity is really a big problem. And chocolate, we got to cut back on the sales. So you guys in the food industry have to produce less chocolate. And the food industry says, we're going to lose a lot of money just for producing less chocolate. And Obama says, just raise the price of celery, for God's sake. I mean, recoup your losses by raising the price of celery. The food industry legitimately complains that celery is a hard enough sell at the existing price. It may be that we're not able to raise the price of celery, and Obama's response, parallel to the existing healthcare debate, don't worry about people not being willing to pay more for celery. We're going to force them to buy a certain quantity of celery. If they don't buy enough celery, we're going to penalize them. So would this mandate to buy celery or pay a fine be a legitimate regulation of interstate health care? Not constitutional as far as I'm concerned. Now, the current Supreme Court might disagree, but there's no precedent that defines that outcome, not Wicker v. Filburn and not Raich v. Gonzalez. The insurance mandate would extend the dominion of the federal government to all manner of human conduct, including non-conduct. And the Democrats will have legislated with this health care bill a new quasi-crime. It's perhaps the only crime in our history that can only be committed by people who have a certain amount of income, because you're exempt from prosecution for this crime if your income falls below a certain level. And even worse, the perpetrators of this crime won't have done anything wrong except not buy a product, namely private health insurance, that they apparently do not want. So Congress's attempt to punish this non-act that harms nobody is an intolerable affront to the Constitution. You can't alter that by calling it health care reform. Federalist 45, James Madison warned us about excessive government powers, and here's what he wrote. The powers delegated by the Constitution to the federal government are few and defined. Now that might have been the intent, but it isn't what in fact has transpired. And as I rattle off this very short list, and it could have been a lot longer, see if you can identify a single power that's authorized by the U.S. Constitution. The federal government today is immersed in matters ranging from our public school system, our welfare system, retirement system, family planning, even aid to the arts, none of which can be found among Congress's enumerated powers. And just as bad, along with this massive enlargement of power, we have government selectively protecting some, but not all, of our constitutionally guaranteed rights. That's too much power, too few freedoms, and it is time to restore a constitutional government. Now, I thank you for your attention over the past 45 minutes or so. I hope the discussion was informative.